Okay, I don't think you can honestly and fairly say that what we do here is breaking news, so let's try that again. Hey, we're back in the shanty. So I was going to make a real effort to try to do these things every 2 weeks, and we're skipping that rule already now. We did one last week. We're going to do another one this week because we do have a couple things going on that I want to talk to you about. And they're two completely unrelated things, but they're things that I either did a shanty on or that I've spoken about recently. And we'll start with the first one. I'll just read the NLRB's headlines. NLRB's joint employer rule vacated by U.S. District Judge. So what's a joint employer rule, you might ask? Well, I spoke about this, I think, back on the 20th of February to an auto roundtable symposium kind of thing. Amanda Fiedler and Zainab and I spoke about a bunch of stuff. This was one of the things. A joint employer rule is the NLRB's employer rule where they take two nominally separate employers and combine them together into what they call a joint employer or a single employer for purposes of the National Labor Relations Act. Here's what the NLRB said about the rule. On Friday evening, U.S. District Judge J. Campbell Barker of the Eastern District of Texas, that was a name made for a Texas court, wasn't it? Vacated the National Labor Relations Board recent rule on determining the standard for joint employer status and the board's rescission of the 2020 joint employer rule. Judge Barker had previously stayed the joint employer rule until March 11, 2024. So the new rule made it much, much easier to find joint employer status than the rule that had been put in place during the Trump administration. And it was a cause for concern for some of you, especially those of you that use a lot of temporary employees. So what the judge did was the judge looked at this rule and vacated it primarily on three grounds. First of all, the judge said that the substance of the new rule, the heart of it, the substance of the regulations was what he called contrary to law. He said that it went way beyond the bounds of the common law definition of the employer-employee relationship and was overly broad. He also said that the rule needed to be vacated because the rescission of the 2020 rule was incorrect under the Administrative Procedures Act, which is a technical legal issue that we're not going to get into. But the final thing the judge said was he was dealing with two issues here that the rule made clear. Number one, an employer who has indirect control can still be a joint employer under the new rule. And number two, an employer who has reserved control can still be a joint employer under the new rule. And the judge didn't like that. He felt that that was overly broad. Basically what he said was, quote, the new rule would, quote, treat virtually every entity that contracts for labor as a joint employer because virtually every contract for third-party labor has terms that impact, at least indirectly, essential terms and conditions of employment, end quote. And that's what the people opposing the rule were concerned about. So that rule has been overturned. Now, before you get too excited, we're not sure what the NLRB is going to do about that, but we're pretty sure they're going to appeal again from the board's news release on this. The district court's decision to vacate the board's rule is, quote, a disappointing setback, but is not the last words on our effort to return our joint employer standard to the common law principles that have been endorsed by other courts, said Chairman Lauren McFerrin. The agency is reviewing the decision and actively considering next steps in this case, period, end quote. So we're likely going to get an appeal. So that's issue number one. If you were worried about the joint employer rule, for now, it's gone. We're back to the 2020 rule, which is much more employer friendly. Okay? So what's issue number two that I want to talk about? Issue number two is the Christian Horner harassment issue, inappropriate conduct issue. We're assuming it was harassment. That's been going on that I did a shanty on last week called Car Wreck. So what's going on there? Well, what's going on there and what jumped out to me off the page is I've been reading that, by the way, Red Bull won again last week by they were so far out in front it wasn't even funny. It's not even competitive. But what I've been reading is that we all know, if we watched the Shanty last week, that Mr. Horner was accused of inappropriate and controlling behavior. There was an investigation done. And I said, so far, so good. Everything Red Bull was doing there was so far, so good. They hired an independent barrister. Well, after they cleared Mr. Horner, they suspended the woman who made the complaint. And I felt that I needed to at least touch on that issue with you guys to make sure that you don't think you can go out and do that. According to the Mirror, I don't know if that's a good newspaper or a bad newspaper in the UK, but according to the Mirror, who was quoting from the Sun, Mr. Horner's accuser is now preparing her to exercise her right to appeal, which is something that she has under English law, apparently. UK law, she has the right to appeal the decision of the investigation that was conducted by the independent barrister. In the meantime, she was suspended. Apparently she showed up to work on a Monday morning and was told to go home. Now, she's been suspended with pay, according to all the papers, and according to the quote I read in the Mirror, quote, "The woman's honesty has been called into question and her evidence was shown to be flawed, period," end quote. I don't know who they're quoting there. I think it's a Red Bull spokesman, but that's the quote from the paper. Now, I wanted to take a minute to tell you guys, just slow your roll a little bit. If you have somebody who raises a harassment complaint, this is not licensed for you to run out and suspend them if you clear the manager or the supervisor or the CEO or whoever else it is, all right? I'm going to read to you from the EEOC. Look, here's what the law is in the United States. I'm going to read to you from the EEOC website. Quote, "The EEO laws prohibit punishing job applicants or employees for asserting their rights to be free from employment discrimination, including harassment. Asserting these EEO rights is called, quote, protected activity, end quote, and it can take many forms. For example, it is unlawful to retaliate against applicants or employees for, number one, filing or being a witness in an EEO charge, complaint, investigation, or lawsuit, period," end quote. Now, does that mean that you can never fire somebody who complains about harassment? That's not what it means. Easy. But you've got to be super careful. Again, from the EEOC. Participating in a complaint process is protected from retaliation under all circumstances. Other acts to oppose discrimination are protected as long as the employee was acting on a reasonable belief that something in the workplace may violate EEO laws, even if he or she did not use legal terminology to describe it, period. Now, the EEOC does give you an out there, but it's a little tiny out. Engaging in EEO activity, however, quote, does not shield an employee from all discipline or discharge. Employers are free to discipline or terminate workers if motivated by non-retaliatory and non-discriminatory reasons that would otherwise result in such consequences, period, end quote. So, you bet if you're going to fire somebody who complains to you about their supervisor harassing them, you better make sure you've got really good proof that what you're firing them for is not raising the complaint. And now it seems to me, and I don't know all the details about what's going on in the UK, that Red Bull's got a problem on their hands. Because this employee showed up for work Monday after having complained about the CEO of the company and got suspended with pay. You don't suspend an employee with pay unless you're going to fire that employee. Unless the employee doesn't want to be in the workplace anymore. They say, I can't work here while you're conducting this investigation. But that does not appear to be what happened here. So I want to caution you, those of you that are reading the newspaper, I don't know what Red Bull's doing here. But if you called me on the facts as I know them now, I would say to you, look, unless we've got dead to rights proof that she lied, you better be really, really careful about firing her. We all know that two people can see two things two entirely different ways, and both of them can be telling the truth in their minds, all right? So you've got to be super careful. And look at the way this works, okay? She complains, they investigate, he gets let off very publicly, Not fired, no discipline, no nothing. The investigation says he did nothing wrong, and she gets suspended. That, whether or not she was suspended for participating in that investigation in the United States is going to turn out to be a fact question in all likelihood. A fact question means you go to a jury. Certainly don't want to be in front of a jury for something like this in the United States. So before you run off and suspend people who make complaints to you or fire them or discipline them in any way, be very, very careful and give us a call before you do it. I would hope we'd be involved in the investigation anyway. So that's it. That's what I wanted to talk about. One more thing. Just one reminder. May 1 will be our annual live and in-person HR seminar. I don't know where it is this year. It's in Grand Rapids. I know that. Look for your invitations coming in the email very, very soon, and we hope to see you all there. See you next time.